And I want to start because Dove, you played such an important part of this brief that you're filing with the Supreme Court. And first of all, let me say, Wopula, for all of your efforts and your energy. And I know you've been having to travel everywhere and do anything, and simply standing and fighting for our people on this. But I think it's important that people understand this is not just an attack on children, but this is an attack on our sovereignty as nations as well, as we've already seen that. Can you just talk to our viewers a little bit about what you've done within your brief and why these issues are more than just that are so important in protecting our children, but more than just that?
Yeah, I appreciate the question, Shaun. First I should give credit and recognition to the attorneys that have been teaching me and have been working with. It's not a solo project. Obviously, also to Lakota Law for all the work they do for Lakota country and Indian country and for Native people across Turtle Island. It's been a privilege to work for you guys for a few years now, and I've been following your organization for a much longer time, and so I'm just here along the way, basically. But what's going on right now is you're seeing a Supreme Court that seems to care little about history. It's not really limited to tribal sovereignty. It's obviously you're seeing it with voting rights, you're seeing it with reproductive rights, you're seeing it with equality in general. And what's going on now is they're going to hear a case in November. They decided yesterday, November 9th, to hear Brackeen versus Holland, and it's going to decide whether the Indian Child Welfare Act, which has been on the books for, as you've said, Shaun, almost at this point, almost 45 years, whether it's still valid and constitutional. And for starters, the law is really important for Native people. It's one of the few laws that tribes across the continent have praised for its significance for safeguarding Native children, for giving their communities deciding power over where their kids go when they're up for adoption. But on the other hand, the law is a foundation. It's a starting point. It's not the be all end all. And so right now the court is going to hear whether this law is valid, whether it's constitutional, and they're going to address one question, which is basically whether it's racist against non-Native people to have a law that basically establishes a preference scheme. So when a Native child is up for adoption, for 100 years, the state would just take the kid and put him in with a white family, cut his hair, tell her to stop speaking her language, and if she didn't, she would be hit, she'd be abused. And the law was there to basically prevent that process from at least happening immediately. It hasn't prevented the process from happening. It's just slowed it and made it harder for white families, or often white Christian saviors, as they call themselves, to redeem Native kids. And so the short end of it is that the law has a provision where if a Native child's up for adoption, if the kid's own parents, can't take care of the child, or the kid's extended family can't take care of the child, the kid's own community will have a say in the child's adoption. And from there, it'll go to any Native person in the U.S. who's a member of a federally recognized tribe, which is itself a controversial conversation. But the short end of it is that you have these very far right wing groups, and I don't mean that with any political valence, it's just how they identify, who see the law as another example of reverse racism. They see the law as something that favors Native people and in the process prevents white families from having the ease of access that they've been so used to for centuries, right? To take Native kids, and not just Native kids. This applies to Black kids. It applies to Latinx kids, Asian kids. One of the Supreme Court justices has a number of adopted Black children, and she's probably one of the biggest threats to the law because she herself believes in the power of redeeming people towards Jesus. I'm not Christian myself, but I believe everyone's entitled to their own faith and religion. But when it becomes something that you push on others, it's a whole different conversation. And so, I mean, there's a million things I could say, but the short end of it is that you have a court right now that seems to have little regard for history, both history of people and societies, but also history of its own law. The court just threw out a precedent, the Roe v. Wade precedent, which people had trusted to be secure for decades. And, a couple weeks ago, they decided that states are allowed to prosecute crimes that happen in Indian country when that for so long that wasn't the case. And the decision that the judges wrote, basically ignored 200 years of not just precedent, but actually what's been going on in Indian country, right? So that's the short end of it, is that what we're faced with right now is two complicated legal questions. On one hand, you could hope the court takes a thorough eye to it and makes it a smart and clear and holistic decision. But on the other hand, given the track record we're seeing in the last year since the court took shape the way it is now, there's a good chance they might just disregard history too and pretend like this law has done more damage than good for people. So I could keep talking about it, but I think I'll rest it there.
Yeah, and I appreciate those comments so much. And I also want to say I appreciate all the comments in the chat. We're going to address a lot of these issues. I'm seeing those, and we want to talk about those issues with you because we know that they're real. Doba, I do want to ask you about this, and I can't wait to speak with Decora on this because Decora is doing with a grandmother's group on the River Reservation is doing a phenomenal job, a life-changing work that they're attempting to get done there. And I want to talk about that in just a moment because the truth is ICWA works. The problem is ICWA isn't working because it's the only law that's not properly, it's not audited, it's not overseen, it's just there. And right. So if it's not overturned at LPLP, we're focused on going to each state individually and making sure that this is fixed and this is right because it does work when it's actually instituted. But I want to ask you this before we move on, because this is the frustrating part for me when it comes to the way this law is being challenged. And for those that aren't familiar, I'll try to give you like the 30 or 45-second, my version of that. I don't know how long that'll be, version of what's going on. There was a Navajo child who had been with the grandparents he was taken from the parents because of substance abuse. And what happened was what's not supposed to happen. He was moved to Texas with a white family, and that white family then tried to when the Navajo Nation found a family member close and had a relationship with the child, they tried to block it from happening. The courts quickly sent it down, and that's when Gibson and Dunn gets involved. And this blows my mind, though. Every time I see it, 6 days after it was turned down, Gibson and Dunn, who is known for fighting for the industry, the companies who are responsible for DAPL, they're responsible for Line 3, I believe Chevron, some other those types. They get involved on this issue, and probably just kind of blows my mind even more. Then the Attorney General for the state of Texas gets involved on the family court level, which is very, very unusual. And perhaps even more unusual, 3 other states come along who only represent about 1% of the population of Native people that would ever face this action. And so there seems definitely to be another objective. But here's the frustrating part for me. They are suing on the fact, ICWA's been challenged before, but they're suing on the fact, if my understanding, please correct me if I'm wrong, though, they're suing on the fact that we should be looked at as races, not nation. And by looking at as races, that the white families is getting reverse discrimination because of this. But the United States has already settled this issue, in my opinion. It should have never been to this point, because the reality is this: the United States of America does not make treaties with organizations or companies or nonprofits. They make treaties with nations, and we are tribal sovereign nation. Article 6, Section 2 of the U.S. Constitution, which all of us are very familiar with, all treaties shall be, not it's recommended or could be or might be or ought to be, all treaties shall be the supreme law of the land. Is that something you were able to address, though, inside of this? Is that the Constitution already tells us we're nations. We have this right.
No, it's a good question. And the thing is with an amicus brief, which is what the court of law provided to the court, an amicus brief is supposed to be a narrow comment. It's supposed to speak from the perspective of the organization or the person involved or who feels relevant. Amicus means a friend of the court. And so, in the briefs for the tribes and for the law in general, they're addressing this issue, right? The nation-to-nation relationship, that any law like ICWA that they're called special treatment laws or preference laws, where a law is written for a specific group of people. That's being addressed in all these other briefs. We had a specific lens, which is from the perspective of the senator who wrote the law in the 70s, named James Aberesk, and he's from South Dakota. He was a huge advocate for Native people, for
Mhm.
oppressed people across the world, a huge opponent of the Vietnam War, of militarism, kind of a rare guy for his times. Um, but yeah, to your point, the law is being challenged because of that. They're saying that Native people are a race group, and that it's any law that exists that privileges Native people is it's racist against other people because it doesn't include those people. Now, as you said, Sean, it's been settled in law for a long time. And when I talked about the history that the court might want to throw out, the court throughout the 1970s and in the 80s passed a number of very, very clear decisions, even where the decisions were against Native people in the end, but they highlighted what they had said in a case in 1974 called Morton versus Mancari, that tribal nations have a what's called a political characteristic, right? They're a classification of politics, not of race. And so a law that is directed towards a tribe or towards Native people largely has nothing to do with race, which is itself a big buzzword invented term, used to kind of suppress difference in a way. But those laws are rooted in those people's membership in nation, a tribal nation, a tribal government. And so, yeah, that's the question here. And anyone who's involved in Indian country knows fully that that's precedent, that is good law. The thing is that we have a court right now that, as I said earlier, doesn't seem to care much for that kind of stuff, and are very quick to jump on to the race baiting bandwagon that we've started to see from the right, especially in the last couple of years. Um, and just to make one point about, you mentioned the family themselves in Texas. Uh, they're openly, they speak about it. It's not something that has to be dug up. They call themselves white saviors. They believe that
Mhm.
that is their mission on Earth. Um, and the most sickening irony of all this is that they successfully adopted the Navajo child. This law firm, which has enormous backing and support from the fossil fuel lobby, as you mentioned, Sean, from the war economy, just major far right, very sketchy interests. Um, they saw a perfect opportunity here because they told this family, well, listen, maybe you've won the adoption or you're about to win the adoption, but the law has made your life hard, right? It's made your life difficult. Now you know what it's like to be the victim of discrimination. And so this family, they ended up wanting to adopt the boy's sister. They said, oh, he'll be better off with his sister, and she'll be better off with her brother. But the short end of it is that they won the adoption proceeding and still claim that the law got in the way of their, equality, their equal rights as people. So, again, it's one of those things I could talk on and on and on about.
Right.
But the background to this was just to finish is that Gibson and Dunn is sponsored by the oil and gas industry, the coal
Right.
lobby, and what they see here is a perfect opportunity to, with the striking of a law, open up Indian country to
Right.
erasure and to take over by industry. And the last part too is that if this law falls, it'll set precedent for a lot of other laws, including casinos, which are questionable in their own way, but give Native communities access to revenue that other groups don't have access to, as well as natural resource law and land use decisions. And so basically, if the court strikes this law and says it's a racist law or it's not, it denies equal protection to non-Native people, you could
Mhm.
see a lot of other things following that will gradually weaken the ability for tribes to, keep around and
Right.
continue to grow their membership and define their own boundaries. And so it's a bigger issue than it looks. It's like an
Right.
iceberg, way more below the surface than you can see.
Absolutely. Appreciate so much those comments. And I can't help but think about the fact that, you have this firm known for their, no DAPL, or excuse me, for DAPL, known for line three, known for all of these. If they can get the Supreme Court to say that we're a race and not nations, now that opens up a whole can of attacks on our tribal sovereignty. Now you can go get all the resources you want because we're not a nation, we're a people, and that's not our land, that's not our rights. And so it's leading to the attempted erasure. That's why I say I believe this is by far the most important crucial time since the 1970s. I want to move now to Decora Hawk. Decora has a tremendous background not only in education in American Indian law, but as an activist and an absolute star for our people, always on the front line fighting. And Decora, when we talk about ICWA, You and I, you've had multiple times. I had an opportunity to go up with you to Cheyenne River, and we sat there and we listened. The first time when I was there, we listened to 9 hours of testimony of people who and children that were absolutely abused by the system, even with the protection that ICWA is supposed to give. And when if ICWA is upheld, then we've got a plan at Lakota People's Law Project to go forth and really begin to see this instituted, overseen, and people held accountable. But as we were going through that Decora, I couldn't help but think about the words of Crazy Horse. After they had defeated Custer and being questioned, he said these words. He said that we never wanted to fight. We never wanted to war with the United States, in other words. All we wanted to do was be left alone and live our lives as we had always lived our life. And that's what I believe we have to say to, to the Supreme Court today. We know best what is best for our children. We know best how to lead our children into who they were created to be. We are best suited to provide, and we are best suited to take care of. And though it may not fit your terms of colonization or your terms of what it's supposed to look like, it works for us. And it works magically. And that's why we've survived years of genocide and all of these things.